Hello everyone, I'm Tracy and today I will talk about the dispute of French marketing firm versus Taco Bell company over a marketing concept. In September 1997, Taco Bell released an advertisement using a Chihuahua image, choosing Taco Bell food over another Chihuahua female dog for northeastern states. And here is the commercials.
Yo quiero Taco Bell.
This Chihuahua advert suddenly became famous and had earned several millions for Taco Bell. The talking dog became a phenomenal success throughout the country, and its lines became pop culture punchline. Yo quiero Taco Bell means I want Taco Bell. Taco Bell was immediately on the maps in those days in a way that it just wasn't before, said Taco Bell Chief Marketing Officer in the year 1997. However, the advert was also facing several controversies, where leaders of some Latino groups have complained that the dog and its accent are demeaning and is a cultural stereotype to Latino people. In the year 1998, Taco Bell got sued by a two-man marketing firm called Ranch for stealing the Chihuahua campaign from them. Taco Bell executives denied and insisted that the Chihuahua commercials idea came during one of their lunch meetings when they saw Chihuahua with attitude ran past the table in a Venice Beach restaurant. Actually, Ranch firm had created a Chihuahua character way before that, and they call it Psycho Chihuahua, and they already marketed it on t-shirts and on other merchandise. In 1996, they attended a licensing trade show where they met Taco Bell creative service department employees called D, who showed interest in the Psycho Chihuahua image. D began to promote Psycho Chihuahua within the company as a potential Taco Bell icon. Ranch firm then hired a licensing agent to continue communications with D. They decided to help D promote the image and make it known by Taco Bell upper management. Ranch licensing agent has met D several times in the year 1997 to discuss about a proposal of the terms for the use of their Psycho Chihuahua image. The proposal required Taco Bell to pay a percentage of the amount spent on advertising, a percentage of retail licensing sales, and a percentage based upon the cost of Chihuahua toys sold at Taco Bell's restaurant. D, at that time, neither accepted nor rejected the proposal. At the same time, Taco Bell marketing department still had interest in the Chihuahua image, but they hired a new advertising agency. This agency, in fact, proposed the exact same advert idea with Ranch firm using Psycho Chihuahua image because they also went to the trade show in New York City and received consent to use that image. They still wanted to use Ranch character and to persuade the marketing department to approve the idea. The materials featuring that character was then passed on to the marketing department. However, they sent it to a new advertising agency, which led to the birth of that successful Chihuahua commercial mentioned above. Ranch firm then proceeded to sue Taco Bell for breach of implied in fact contract, which is a contract when a party can show that both parties understood compensation would be paid for service provided. Idea misappropriation, which is the use of someone else's ideas without permissions. Conversion, which is the unauthorized use or control of someone's property. And unfair competition. Taco Bell argued that there was no implied in fact contract, and even if there was, it would be preempted, which means conflict by federal copyright law. They also argued that the idea to use Chihuahua came from its new advertising agency, and Ranch ideas were not original. Taco Bell then won the first trial. Ranch never gave up, appealed the case and to the Sixth Circuit, and the Sixth Circuit reversed, finding the contract claims were not preempted by the Federal Copyright Act. In 2003, Ranch firm finally won the case and won over $30 million in damages from a jury. Ideas misappropriation happens a lot in business competition. A similar case to this is the case of Davis versus General Foods Corp. Davis wrote a letter to General Foods offering to review an idea for a new product. General Foods then responded with a letter saying they would consider her idea, but her compensation would solely depend on their discretion. She then agreed and wrote back explaining her idea, hoping she would be able to have compensation. General Foods, however, used the idea without paying her anything. She took the case to court, but the court said the letter was too vague to be considered a contract, as well as the choice of words in those letters did suggest a possibility of no payment at all were recognized. So General Foods won the case and didn't have to pay anything. Even though the process of this case is quite similar to the ranch firm versus Taco Bell, Davis in this case hasn't had her idea licensed and did not receive any advice from attorney. If only she met an attorney before revealing her ideas, she could have made a lot of money. In conclusion, idea theft has been known as a common thing in every industry, so it's important to know how to protect your ideas from being stolen by doing proper registration for your intellectual property. Choose your partner carefully and document everything during discussion to prepare for the worst case scenarios. Also, always remember to consult with an attorney. That is also the end of my presentation, and I have two questions for you guys. First, do you think it's fair for Taco Bell to lose the case while they have no written agreement with Red Firm about the use of the Chihuahua image? Why and why not? Second, what do you think Davis could have done to avoid her ideas from being stolen by General Foods Corp? What would you do if you were her? Please answer my question on Fungse 1. Thank you so much. He is my reference and he is my image source. Thank you.